said as regards this committee. It said, we recommend the committee route as opposed to this lynching. The words lynching came from them there. Mob justice. That said they did not conduct a constitutionally compliant public participation exercise, and as I said, it's required not only by the law, Articles 10, Article 118, Section 5 of the Fair Administrative Action Act, but again, my lords and your ladyship will have time to look at the BAT case, again the Supreme Court case, that gave the 8 or 10 criteria that are to be looked into in examining whether public participation was properly carried out or not. Among the other criteria that the court is to look into, again from the same Section 7, is whether the administrator failed to take into account relevant considerations and took its action or made the decision in bad faith. Did they consider everything they ought to have? I have a long list of things here, and I won't spend any narration on them. 1, they did not take into account the Wambora Court of Appeal principles on the threshold test for impeachment. That is where the threshold test was made. They did not take into account the Sonko Supreme Court case principles on the need for a special committee. They did not take into account the BAT Supreme Court case principles on public participation. They did not take into account the Onyango Olo Court of Appeal case principles on fair hearing, and in particular, what is adequate time given the circumstances. At this point, I should point out, when the Supreme Court is determining whether to annul or uphold the president's election, it normally has 14 days. It normally gives a summary judgment and then reserves reasons for many months later, again because there just isn't sufficient time. And so, why the National Assembly and the Supreme Court in 2022, in its judgment, actually said we ought to amend the Constitution to provide for more time, you know? Now, why the National Assembly, which has been asked this, and in fact, in 2022, the Supreme Court said this judgment should be served on the National Assembly for them to remedy this question. Both National Assembly and Senate did not take into account Article 50 on the fair hearing requirements. They did not take into account Article 94(4) of the Constitution, which requires them to protect the Constitution and promote the democratic governance of the Republic. I've already cited Section 5 of the Fair Administrative Action Act and other provisions of that act. The resolution by the National Assembly adopting these allegations, which concerned spurious, frivolous, vexatious matters about the first petitioner's family matters, which had been dealt with by a succession court, which was the subject of rulings by the family division, were thrown in just for the heck of it to harass the man, and were designed to violate his rights under Article 31C, which protects every citizen from having information relating to their family or private affairs unnecessarily required or revealed. And in the fullness of time, you will find the Senate actually refused to uphold this ground. The ground had been put there purely to embarrass him, to embarrass his family, to embarrass his supporters, to harass the man. That cannot be a proper motive. That is an improper motive by this party. They failed to consider that the DP, and again, this is the Alai case. My good friend, Mr. Dudley, referred you to the Alai case. In the Alai case, the court said, and there'll be another case I'll be reading out here for you shortly, called Ferdinand Waitito, that you are free to express your opinion. And so, as I said, the first petitioner begins at paragraph 65 by saying all his problems are because he spoke about the manner in which his government had mismanaged the demonstrations by these young people called the Gen Z. Now, we are about to compensate them for shooting and killing them. Now, this will be the first judicial decision that will provide guidance on the interplay. This is an important one because it keeps being repeated, and my learned friends here have paragraphs upon it in their submissions. The interplay between hate speech and incitement which are stated to be offenses under sections 13 and 62 of the National Cohesion Act, vis-a-vis the freedom of expression under Article 33, the political rights at Article 38(3)(c), and the rights of all citizens, including political leaders, to advocate for and protect, express ethnic rights identified in the Constitution. I say ethnic rights with that reason. The first petitioner is accused of starting hatred, potentially inciting people, because he used the word Mount Kenya. The little geography I learned, Mount Kenya is a rock in the middle of Kenya. It is not a tribe. It's a stone in the middle of Kenya from which we got our name as a republic. Even if you are to count the counties that surround it, they constitute people from every corner of Kenya. They don't have one tribe. He didn't use a tribe. He said Mount Kenya. Mount Kenya is a rock. He can talk about a rock. Number two, even if he was talking about ethnicity, Articles 21, 27, 63, 90, 91, 100, 130, 232, 241, 246, 250, and a myriad of statutory provisions that I could bring here all talk about ethnicity as a constitutional principle worth defending, worth being held to account for, worth advocating. All of those mention the word. In fact, I found that the word ethnicity appears more times than the word economy. Economy appears twice. Ethnicity 11 times. So, how can you be accused of speaking of an issue the Constitution spent 11 articles talking about? But even more important, in 2016, the late Justice Louis Onguto had occasion to consider a case I have circulated to my colleagues this morning after I got their submissions, and I think I have given the court, my good friend Mr. Njomo, the court's copies. But this is the case of Ferdinand Dongo Waitito, also known as Babayao, and 4 others, versus the Attorney General. It's reported. This is what Judge... such as those about to be made by the respondents. And this is what it says. The Constitution allows every person to picket, demonstrate, assemble, and present petitions. Picketing and demonstrations themselves invite the right to express opinion. The opinions may be controversial. The opinions may appear contrary to the law. Appear contrary to the law. This is just what Jayongo saying this. The opinions may not find favor with others. Yet, the Constitution anticipates and expects that such unpopular opinions, howsoever expressed, be respected. Now, not all of us can speak as good English as my good friend Dudley or my good friend Professor Ujiambo here. But you're free to express yourself as you will. If you read a document that talked about shareholders, that is what you say when you go to the public. Why would you be vilified and impeached from ever holding public office for reading a document that founded a government? On what basis? He then says, even if they invite disagreements and counter demonstrations, this is the first time, I think it's good, Kenyans would know, counter demonstrations are allowed, not just demonstrations, even counter. The Constitution thus far declines to stifle even the most unpopular view unless it is intended to incite persons to violence, propagate hate speech, is propaganda for war, or advocates hatred through ethnic incitement. When you retire to look at the provisions of the National Cohesion Act, sections 13 and 62, that are the basis of these frivolous grounds, they say the critical function is what my professor, Gideon Muigai of criminal law, used to tell us was called the mens rea, the intention. Did you have the intention to cause hatred and incitement? You cannot have had the...
Did you know it takes minutes to become a Darif affiliate? First, sign up on darif.com/partners. Next, confirm your email. After that, fill in your information. Lastly, get approved and access your unique link. Everything you need to promote Darif is ready for you. Sign up today and grow as a Darif partner.
They cannot. This is public speaking, as I've just stated. And I should state here, the case of Ferdinand Ndung'u Waitito and the 4 others, among the 4 others, are the current leader of majority in the National Assembly. So he knows this. When they were considering these grounds, he was aware of this decision because he was one of the petitioners. And they were told, no, you can't stop people from talking. Now, but then, they then went to the Supreme Court, the Court of Appeal, sorry. They tried to overturn this decision, and the Court of Appeal rejected that attempt. So this decision, I'm reading Ferdinand Waitito, has been upheld as well by the Court of Appeal. There are many instances where one would be said to have caused the hate speech or incited people or have said things that weren't popular. The first petitioner is accused of having spoken against the National Intelligence Service. When you retire to review the material before you, this is the Senate Hansard, and this is ground number 9, which you'll find at page 64. There is an interesting exchange where my good friend Ekomas Mutuse is being interviewed, is being cross-examined on the question of the NIS. And he's directed to a case where the current president, who, while deputy president, also very harshly criticized the NIS. So criticizing the NIS has not started now. In fact, the current first petitioner, who was the deputy president, should be accused of being a good student of his boss, the former deputy president, who's currently the president, because he too also criticized the NIS. So, and the NIS, as with any other state organ, can and should be criticized. No one is beyond criticism so long as it is well-founded, as turned out in this case. It is made politely. It is stated in good English, relatively good English. Our client spoke some fairly good English. He's a literature graduate. He said nice things. He said them nicely. Now they offended the heart, but you know, no one is beyond criticism. One of the other things, I think, and we've stated this in our petition and submission, again on the question of bias, the National Assembly Deputy Speaker, the 8th respondent, is on record as saying her instructions to execute the impeachment came from a building in Kilimani called State House. And one of the things the court is invited to look at is whether the person exercising this decision acted on the direction of a person or a body not authorized or empowered to give such directions. Now, one of the other issues that this court is asked to look into is whether the administrative action is rationally connected to the information before the administration. Again, as I have said, it cannot have been rationally connected to this decision when among the grounds was a law that did not exist, was issues pending before the succession court, was the exercise of freedom of expression under Article 33. I will not repeat the question about the issue, but it's one of the other issues, again, you'll be able to look at. The question of these shareholder agreements, I need not say any more about that. But is the decision unreasonable? The ungodly rush to execute a premeditated decision is unreasonable. A one-day notice to the public to conduct public participation regarding a matter that even this court has said is of great public importance is unreasonable. Conducting public participation in which the public only has access to the impeachment motion, a summary of it, by the way. The evidence was not given to the public. They were just told he has violated Article this, Section this, and Section that. Most lawyers could not tell you, with most, leave alone the public, other than my good friend Mr. Umtata. No public member can read these sections out of their head. And yet this is what they were given on this document and told, should we impeach this man or not? Passing a resolution based on public participation, as I said, that had 0% of voters who cast the votes in 2022, is unreasonable. One of the other criteria is whether the administrative action or decision is not proportionate to the interests or rights affected, and whether the impugned action or decision violated the legitimate expectations of not only the deputy president, but the nation at large. Now, the case I cited earlier, which is the 2025 IBC versus AG case, states the following words. Kenya's history is one of executive overreach and institutional compromise. This is what the Supreme Court said last year. And for the avoidance of doubt, Section 12 of the Fair Administrative Action Act states that the act is in addition to and not in derogation of the general principles of common law and of natural justice. Now, as I said, the National Assembly and the Senate violated all known canons of fair hearing and constitutional procedure. Amongst the most harmful things they did was to destroy almost the principle known as the principle of legitimacy. The principle of legitimacy has three pillars. Pillar number one, people must have voices and their voices must count. That's the first pillar of the principle of legitimacy. The second one is that public affairs and the law must be conducted with fairness and justice. That too was violated. And thirdly, that laws and rules must be consistent and applied evenly and predictably. I repeat, the current Deputy President is the witness of these shareholder agreements that led to the impeachment of the Deputy President seated here. The President, the Speaker of the National Assembly, the Speaker of the Senate, all are members of parties that signed and are beneficiaries of this agreement. How can we say the law is being applied equally, fairly, and evenly, even in the limited space of the political players, when one group is treated one way and one individual is treated another way? I want to rest this area of my submissions, and perhaps maybe you should allow me to just read for you, as I found my notes on the provisions of the Elections Act and the IBC Act that deal with the question of nominating a deputy president. These are articles 82(1)(b), Article 88(4), the definition of the word nomination at Section 2 of the Elections Act, Section 22 of the Elections Act, and Section 4D of the IEBC Act. I want to close with the following paragraph taken from the decision of the IEBC versus Attorney General 2025 case. This was a case concerning the delimitation of boundaries, and the Supreme Court of Kenya said as follows. And this is the penultimate paragraph of their judgment. However, before we conclude, we must address a matter that has troubled us. And it is my very, very tremendous
Чай на ураз. Заваривайте праздник.
in this matter. The history of Kenya's electoral process, from the findings of the Kriegler Commission after the 2007-2008 post-election crisis, to the litigation around elections culminating in the 2022 presidential election, reveals a consistent theme, one of a deep-seated trust deficit. I beseech this court, do not countenance any further trust deficit based on the things the National Assembly and the Senate did. Trust deficit between Kenyans, the IEBC, and the electoral process. This deficit did not occur by accident. It occurred because of actions like the ones by the National Assembly and the Senate. Rather, it is the product of decades of politicization of the electoral process, relentless attacks on the Commission's independence, and a failure to implement electoral reforms in a good time and in good faith. Leaders exercising delegated authority, such as the National Assembly and the Senate, on behalf of the people under the Constitution, rather than fueling this mistrust for short-term political gain. It appeared last year, 2024, when the impeachment was going on. It seemed that there was a deadline by 20th October. And when I slept, I woke up with a eureka moment. The idea was to have a new deputy president at the holiday. You know, it gripped me. I hadn't seen it before, you know. And so undermining the very institutions they are duty-bound to protect should channel their power and influence toward addressing structural weaknesses, enhancing accountability, and reinforcing public confidence in the impartiality and competence of the IBC. In this case, I say of decisions by the two bodies before you. Ultimately, the legitimacy, which is why I spent some time talking about the doctrine of legitimacy, and this is what they say. Ultimately, the legitimacy of Kenya's democratic order depends not only on credible institutions, but equally on the fidelity of political actors to the spirit of the Constitution and the sovereignty of the people, which was in question during this impeachment. Unless your ladyship and my lords have any questions for me, I want to thank you for the privilege of your time and attention. I'll rest at that point. I hand over to my senior, Mr. Swanya.
Thank you. Repeated issues are coming up in your submissions, and I want us to believe that we have heard most of those issues. If you find that you are bound to repeat what has been said, we want to assure you that it is not necessary.
Thank you. My name is Swanya. I'll address the court on notices. But before I do so, let me cite the Supreme Court, a case on PAT, which says public participation is a constitutional requirement under Article 10 and 118 of the 2010 Constitution. The Supreme Court, in a PAT case, held that public participation and consultation is a living principle that went into the constitutional tenet of the sovereign of the people. Under Article 10, Sub-Article 1 and 2, as a constitutional principle, public participation binds and it is applied to all aspects of governance. Your Honors, and Lady, I want just to get down to some specifics on public participation. It is designed to ensure accountability, requiring public engagement, rather than just parliamentary approval. In the context of impeachment, it is a remedy of the last resort. This, I think, was mentioned by Senior Counsel Paul Mwite. Therefore, the public participation exercise must meet the following standards, and this is what I wanted to get down to the specifics. One, must be purposeful and meaningful. Must be real and not illusory formality. It is not cosmetically done for Public Relations Act. Should not be undertaken as a matter of trust to fulfill a constitutional requirement. The public participation exercise outcome must have quantitative and qualitative components. It is accompanied by reasonable notices and reasonable opportunity. Further, Your Honor, the court tried to highlight what is the components of meaningful and purposeful public participation. It must have clarity of the subject matter of the public, for the public to understand. The structure and process, that's the media of communication, of the participation, participation that are clear and simple to understand and follow. This particularly is the instruments that are used to collect data ought to be given to the participants on public participation, they got to be simple, clear, and easy to follow. There must be opportunity of balanced influences from the public in general and commitment to the process. It must be inclusive of effective representation, integrity and transparency of the process, and capacity to engage on the public, including that the public had to be first be sensitized on the subject matter. These are the details that or guidelines the Supreme Court gave on the PAT case. So now let me just get straight to the notices. Before I get to the details of it, let me define what a notice is and a reasonable notice. A notice is a formal information to parties attached or necessary to a judicial process, informing them about the issues they need to know and given an opportunity to respond to them. The courts always will rely on the parties to properly serve notices to the affected parties. A proper notice is regarded to be proper and adequate when it has the following elements. Number one, it must be in writing and indicate the date issued. It must be clear and precise, or state the clear and precise object of the notice. Provide specific venue and duration if necessary. Provide adequate timelines and periods as may be stated in a statute or an agreement. It must refer to a statutory or an agreement or resolutions, and of course must be served. In the case of Battle versus Globe and Mails Limited, kicks in. It is a common law concept that refers to fair amount of time that must be provided for the parties to respond to a matter that concerns them before a decision is arrived. The Lord, I brought this up because we do not have a codified law that guides the impeachment process, which has guidelines on the notices and durations, or steps to be taken for an impeachment. And what we have only is what the Supreme Court, in the case of PAT, has given as guidelines. And so one of it is reasonable notice is necessary. And that's why I've referred this case where there's no notice, then automatically a reasonable notice kicks in, and it talks about the timelines. Now let me state also in the case of Robert and Gakuru versus Governor Kiambu County, the court has been clear that arid or poorly publicized processes amount to illusory participation, being a formality incapable of influencing the decision. Therefore, reasonable notice to the 290 constituencies must be understood as notice that is sufficiently served early, widely disseminated, and accompanied by accessible information for realistically enable the citizens to engage. Anything less, particularly involving inordinately compressed timeline undermines the Constitution standard by denying the public a genuine opportunity to study the issues and be able to formulate a position and present meaningful representation capable of shaping the final decision as in the present case. Your Honors, I now submit on the National Assembly's failure to meet the standard of reasonableness and meaningful engagement. The National Assembly, in their own report, reveals a process that prioritized speed over substance, failing the reasonableness test as follows. The notice ran for only 2 days. That is on 2nd and 3rd October 2024 for the public participation exercise, which was to be held on 4th of October 2024 at a purported initially a designated single venue at the county level. Additionally, the National Assembly report on 3rd and 4th October 2024 stated they had 40,000 copies of the notice of the special motion were circulated as newspaper pullouts. This begs the question whether the 40,000 copies were adequate for meaningful national public participation and whether the 2 days were adequate for circulation motion containing 11 complex grounds, legal grounds, including allegations of corruption and gross economic crimes. Your Honor, it's important to note that the first notice had a single venue per county. Your Honor, you can imagine an headquarter of a county, assuming that's where the exercise was taking place. The people who are at the ends of the county, how would they access to reach the venue and participate in the public participation exercise? This is contrary to actually what the Court of Appeal, the Supreme Court, rather, guidelines had provided for. The other point, Your Honor, according to the report, the nationwide public participation exercise at the constituency level gave 1 day notice on 4th of October 2024, the same date as the court ruling. Let me clarify here that the participation exercise was supposed to be on 4th of October 2024 for 1 day. But the ruling of Justice Moho, your brother, extended the participation for another 1 more day. Now that advertisement or publication also came in the same day when these exercises were supposed to finish. Now, what would happen that to the common mwananchi? Of course, confusion. Similarly, the orders which were given said that now the exercise should move from the county to the constituencies. The Honor, what we notice here is that in the constituencies, just talked about constituencies, never gave a specific place, address, where this exercise is supposed to take place. It's our submission that such an important exercise to remove the deputy president from office, who was elected by the majority of Kenyan in each gazetted polling station in the country, required a similar methodology and the participation to remove him from office. And certainly, the purported NGCDF officers advertised without prescribed venue address did not meet Justice Mwongo's court order to provide venues close to the people. In any case, the only venue close to the people is polling stations. The honor here, as I said earlier, even with the orders, needed to have the exercise done at the constituency level. And the assumption here is that each constituency has these offices. But then what's the distance between where those offices are? They were not prescribed for somebody who's at the end of the corner of that constituency. By using highly legalistic language in the notices of public participation and in the circulated public view template, the assembly created a barrier to entry for the average mwananchi, reducing a constitutional right to a binary of support or oppose vote.
People ask about my design process. It's about only keeping what matters. The Dbot T90 has that same quality. It doesn't try to be noticed. It does the job and disappears.
Ecovacs, created for ease.
Technologically biased and excluded vulnerable groups. In the BPI case, the court stated that relying heavily on technology ignores the reality that only small fraction of Kenyan as reliable internet access, and that technology has not been dispersed equitably to all Kenyans. Similarly, despite the Persons with Disability Act of 2025 requiring free sign language and braille in public forums, the GACHAGUA impeachment exercise failed to provide even the most basic reasonable accommodation for these 5% of the population with special needs regarding the exercise, which was unconstitutional as per Article 54. The report does not demonstrate that the public was provided with copies of the special motion, including the grounds in English, Kiswahili, prayer, and other communication channels and technology accessible to persons with disability, such as the Kenya Sign Language. In Turkana, as an example, as well as other marginalized regions where the report shows zero response via hand delivery and email, the report does not demonstrate whether it provided any mobile registration units or outreach as required by the PPI case to ensure nomadic communities were also involved. The notice, as I think has been mentioned again, presents a one-sided script. It presents the public with the grounds for impeachment without the first petitioner's response. This was not a search for truth. It was an exercise in prejudice. By suppressing the petitioner's side of the story, the state violated its rights to fair hearing and public's right to make an informed decision under Article 47 and 50 respectively. And this is found in our submissions, page 48 and paragraph 107. One submit that since the reasonableness of the notice is to be determined on case-by-case basis, the adequacy of notice in the present impeachment process can be tested against the scale of electoral mandate it seeks to overturn. This is found also in our submissions, page 47 and paragraph 104. In 2022 Kenyan general election, the presidential mandate was exercised by approximately 14.3 million voters, out of about 22.1 million registered voters nationwide, reflecting a wide democratic participation. Out of those who cast valid votes, roughly 7.1 million supported the ticket of William Ruto and Rigathi Gachagua, thereby conferring upon them the constitutional mandate to govern. This mandate was granted by voters decentralized across the 290 constituencies and dispersed across at least 24 counties in accordance with the constitutional requirements. That is also in our submission, page 4 and paragraph 2. Therefore, by contrast, a constitutionality compliant impeachment process ought to demonstrate that the public participation notices reached a substantial and representative proportion of that electorate. In the present case, the notice issued reached only a negligible fraction of the electorate, attributed to short times, limited publication channels, and accessibility to forums, which processes clearly falls short of the constitutional standards. And of course, my learned friend Tom Macharia has mentioned that this is evidenced by the alleged 200,000 plus viewers in the National Assembly report, which constitutes about 0.14% of the vote that mandated their win. Your Honor, statistically, of course, it sums up to a 0%. If it was a medical test, it will show negative results. There were only 11 memoranda that were presented to Parliament. Your Honor, and again, this I think has been said, I won't repeat it. This begs the question whether the National Assembly is suggesting that the sovereign will of 22.1 million registered voters in the nation is carried in the pockets of the 200 plus individuals who allegedly participated in the exercise. Your Honor, as you retire, you will find that the National Assembly's failure to issue reasonable notices contributed to the dismal performances in the public participation exercise, which cannot be taken to proportionately hold the views of the majority who voted the President and Deputy President into office. I also dare to say that the mode of the instruments that were used to collect information, the template instruments used in the public participation exercise lacked clarity, thus ambiguous, contrary to the Supreme Court guidelines. The viewers template instruments to collect data from the public participation exercise failed verification and identifiability test. And of course, we've mentioned that initially, which I think is a point to note, they were the first templates that did not have provision for identification. Then later, they were replaced. But we don't know the forms that were already in the public. What happened with them? Did they collect data? Is that data part of what was collected and reviewed? That information we don't know. Parliament equally did not state clearly how they were verifying the information they got from the public. Finally, let me just finish now.
If you walked into a company and asked where their IP assets are stored, no one could point to a shelf or cabinet. These invisible resources don't look like assets, yet they control your entire digital footprint. Maybe that's why they're overlooked. But invisibility doesn't mean insignificance. And as the internet grows more complex, the organizations that treat IPs like critical infrastructure will outpace the ones that treat them like temporary tools. So the question is, are we ready to rethink how we value the foundations of the internet? Join NRS. Be empowered to own and protect your digital identity.
That straddle the line between legal and political domains. There is no doubt that many are watching to see how the court will navigate this delicate issue. One that has significant implication for the doctrine of separation of power. Your Honors, the eyes of the nation are indeed upon this court. We echo your sentiments in paragraph 101, which reminds us that the people of Kenya fought for a transition away from marginalized judiciary. They envisioned a new order where government excesses are checked and where no harm of government operated beyond scrutiny. If the standard of public participation is allowed to fall as low as it did in this case, characterized by unverified templates, digital exclusion, and binary trap, then the Constitution promise of the will of the people becomes a dead letter. Thank you, Your Honors, for the opportunity to address you.
Thank you.
May it please your lordships and your ladyship, my name is Faith Waigwa for the first petitioner. My lord, I shall be addressing you on issue G. Issue G is the second last issue framed by the first petitioner and speaks to the invalidity of National Assembly Standing Order number 64. To start off, my lord, at paragraph 147 of the first petitioner's submissions dated 7th October 2025, we did highlight the issue as National Assembly Order number 46 as opposed to 64. So we wish to correct that now. The body of the paragraph speaks to the correct provision, which is 64. It's just the heading that there was a spelling mistake. My lord, the question we pose on this issue is, can an internal procedure of Parliament, internal procedure rule of Parliament, namely the National Assembly Standing Order 64, constitutionally compress an impeachment process of the magnitude where a deputy president is being removed into timelines so short that they effectively extinguish the constitutional duty to facilitate meaningful public participation? My learned colleagues and seniors have ably submitted on the issue of public participation, but I'll try as much as possible not to repeat, though, my lords, you'll allow me to demonstrate why this particular provision of the standing order goes against the constitution provisions of public participation. And to that extent, we will be answering our question in the negative. And towards the end, we will invite you, my lords and my lady, to find that that standing order 64 2 in specific, and to the extent relevant, 64(6) are unconstitutional, null and void, to the extent that they impose timelines whose purpose and effect is to undermine Article 10 of the national values, Article 118 on participation by the public, Article 1 on sovereignty, Article 2 and Article 124 of the Constitution. My Lord, this is not an attack on parliamentary autonomy. It is a defense of constitutional supremacy, and we proceed to demonstrate as follows. A procedural rule that makes meaningful public participation impossible is itself unconstitutional, however neatly drafted. The vice in Standing Order 64 is not merely that it provides timelines. The problem is that those timelines are constitutionally disabling. And I will demonstrate what Standing Order 64 provides. It requires, 1, the National Assembly's Speaker to dispose of an impeachment motion within 3 days of its notification. Thereafter, it provides the disposal of the impeachment motion by the National Assembly within a period of only 7 days. We have 339 members of the National Assembly who are supposed to dispose of the impeachment motion within 7 days. And lastly, it provides for transmission of the resolution of the National Assembly once they've passed the motion to the Senate within 2 days. The real vice falls under under Standing Order 64(2), where the National Assembly has only 7 days within which to dispose of the impeachment motion. This standing order compresses a matter involving reversal of several sovereign electoral choice into 12 days, thereby making meaningful public participation illusory. And where participation becomes illusory, Articles 10 on participation of the people being a national value and principle of governance is affected. And Article 118 on public access and participation is also affected. Article 2, my Lord, of the Constitution is supreme. Anything inconsistent with it is void. The standing orders themselves derive their authority under Article 124 of the Constitution, and therefore, they do not sit above the Constitution and cannot cut down constitutional obligations. The Supreme Court.
We are in the business of action, of taking the hard path, of untethered ambition and restless innovation, of leveraging strong connections and accelerating growth, harnessing local opportunities on a global scale, nurturing masters of the art and empowering their craft. We are in the business of never slowing down. Because when you serve a 40 million strong nation with unmatched regional economic potential, the endless pursuit of greatness becomes your business. Hugamara Group, making greatness every day.
My lords and my lady, constitutionality is judged not only by text, but by purpose and effect. So we look at what is the purpose of Standing Order number 64-2. Its purpose is to force expedited disposal of impeachment motions. But what is its effect? In reverse, to restrict Parliament ability to facilitate meaningful public participation in the impeachment proceedings. With this, Standing Order number 64-2 has a purpose and effect that undermines constitutional rights and national values and principles of governance, and therefore should be found to be invalid. The petitioner specifically pleads this at paragraph 98 of its further amended petition. And that is the vice before this honorable court. My lords and my lady, impeachment is not ordinary parliament business, and that has been admitted by the respondents when they say impeachment is not necessarily a legislative process. It seeks removal of a directly elected constitutional office holder, and in practical terms, revisits the sovereign will expressed at the ballot. It is that serious. Such a process demands heightened constitutional safeguards, not reduced ones, like we have seen in Standing Order number 64. Yet Standing Order 64 does exactly the opposite, my lord. That inversion should then be found to be unconstitutional. My lord, I won't repeat what has been submitted before you on public participation. However, you've heard clearly that public participation conducted on the 4th and 5th of October 2024 did not meet the threshold of the principles laid out in the BAT case. This is the British American Tobacco Kenya PLC versus Cabinet Secretary of the Ministry of Health. And allow me to just point out what violations were made. And had we had more time, had the National Assembly provided for more time in its standing orders, perhaps they would have averted these particular violations. One, Mr. Swanya indicated of the no reasonable notice was issued. A notice of extension of public participation was issued on the 5th of October 2024, which was the last day and D-Day for public participation. There was no reasonable notice whatsoever. There was no informed participation. The people of Kenya were provided with information that was minus the defense by the first petitioner, where they had one-sided story for them to consider whether to impeach or not to impeach the second deputy president. There was no balanced influence. We've heard clearly that at Bomas of Kenya, participants were actually told that the forum was for invited members of the Orange Democratic Movement. That's ODM party. Members of parliament swayed participants during this engagement. We've heard that. Therefore, the process was partisan and violates the requirement of balanced influence. We've also heard of the no integrity or transparency because forms were unverified and cannot still be verified to date. No serial numbers on those forms that were used for public participation. No methodology was disclosed. And statistical anomalies such as 162.78% support in Keyo South was reported. Clearly, we will all agree that this speaks to constitutional fraud. Again, my Lord, I reiterate, if the National Assembly had more than the 7 days required to dispose of this notice, this motion, impeachment motion, then perhaps these violations would have been averted. The respondents may argue timelines alone do not invalidate a process. However, our response would be not every short timeline is unconstitutional. So we might agree. But a timeline becomes unconstitutional where it makes constitutional compliance impossible. And that is the case with Standing Order number 64. Why do we say the timelines there are unreasonable? First, it allows no genuine civic education before participation, because the public participation was conducted by National Assembly. Second, it allows no adequate dissemination of relevant information across 290 counties. Third, it allows no serious compilation, analysis, and debate on public views, and violates procedural fairness. The fact that the defense of the first petitioner was never disseminated to the public to make an informed decision, that process was unfair. My Lord, allow me to compare these timelines with those of the presidential election petition. We all know and understand that a presidential election petition is filed by a person who has arguably lost a presidential election. This petition is supposed to be heard and determined within 14 days by a 7-judge bench. In contrast, when removing the same president who's been confirmed perhaps in the presidential petition, the National Assembly allocates itself only 7 days to remove a president or a deputy president who was validly elected using universal suffrage, and the people sitting to remove the president or the deputy president.
Did you know? Signing up as a DARIF affiliate is completely free. No fees, no upfront costs. Wherever you are, you'll find the tools you need. Get started without spending a cent. Joining is simple and designed to be effortless, so you can focus on growing your partnership. Join for free and become a DARIF partner today.
President or deputy president must be extremely fast. My lords and my lady, I'll draw some comparatives from parliamentary systems of government, which my learned colleague, Ochiel Dudley, was able to bring to your attention. We did the research with him. In Nigeria, the timelines are 4 to 5 months. 4 to 5 months for the entire process. In Kenya, the process is around 2 weeks to 4 weeks maximum. In South Korea, Constitutional Court is given up to 180 days to render its determination. In the US, my lords and my lady, we will be surprised that there are no rigid timetable. But historically, what has been happening is around 2 months or more. And the reason is that the flexibility exists because of the gravity of such matters that demand deliberation. So you will find from the countries we've drawn your attention to is that they are more of an investigative process as opposed to a mob justice process that took place in our country at the National Assembly. Why are we comparing this? This comparative material is not cited to import foreign constitutions. It is cited to illuminate a constitutional principle. Basically, Kenya is an outlier when it comes to timelines for removal of its president or its deputy president. Where removal overturns a popular mandate, constitutional democracies favor deliberation, investigation, and participatory legitimacy, not speed. I repeat, my lords, not speed. So the Kenya's National Assembly Standing Order 64 runs opposite to this democratic pattern. Article 124 creates standing orders as subordinate procedural instruments. Being subordinate procedural instruments, they therefore cannot dilute Article 10 on participation of the people as a national value and principle of governance. They cannot dilute Article 118 on public access and participation. They cannot dilute Article 1 on sovereignty of the people. They cannot dilute Article 47 on fairness in administrative actions and quasi-judicial outcomes and decision. My lord, they cannot dilute Article 50 on fair hearing and Article 2 on the supremacy of the Constitution. As I conclude, my lord, constitutional obligations are not optional where timelines are tight. If timelines make it impossible, then those timelines must yield, not the Constitution to yield. My lords and my lady, would want you to look at expediting the process as a value, but participation of the people should be looked at as a constitutional command. When they conflict, then the Constitution prevails. We respectfully invite this Honorable Court to hold that the National Assembly Standing Order 64-2, and to the extent inconsistent Standing Order 64-6, why we say so, my lady and my lords, is because the 2-day timelines is provided in the Constitution. That is what has been captured under Standing Order 64-6. Violate Articles 10, 118, 1, 2, and 124. If you find favor with our prayer, then Standing Order 64, 2 and 6 should then be found to be invalid for being unconstitutional. My lady and my lords, as you retire to write your judgment, we need to answer to this question. We kindly request that you address yourselves to, can sovereign will expressed through election be reversed through a process too hurried, like that at the National Assembly having been given 7 days for the people to meaningfully participate in it. We look forward to a respectful answer of no. And for these reasons, we respectfully urge this Honorable Court to declare the Standing Order 64-2 and 64-6 as unconstitutional, null and void, to the extent they impose timelines whose purpose and effect is to undermine the articles that are mentioned, 10, 118, 1, 2, and 124 of the Constitution. I so respectfully submit. Thank you.
Thank you.
My Lord and my Lady, my name is Njomo John, appearing for the first petition of my colleagues, and I'll pick up from where my learned colleague Faith Waigo has left. I rise to briefly submit on the reliefs that the first petitioner is seeking before you. I know counsel who has submitted before me have mentioned variously part of what I'm submitting on, and that is the reason why I will not take long. My Lord, when this court delivered its ruling on the 31st of October last year, I want to refer to paragraph 158.
Hello?
Uncle Mo?
Yes?
This is Absa. We have a new date for the Seven Hills Run. It is 17th May, and we have concluded you will be our MC, but on one condition. You must run.
Can I run like on Teams?
No.
No,
We're
I
looking
can't start
forward.
to Do you have some glucose? 2 sacks.
This matter, so that when we come before you, this court has an open page. All the reliefs that the petitioner is seeking are grantable by the court, because even Professor Githu Muigai, it's on record that he has given an undertaking that there will be full compliance. So that, my Lord, the reliefs that the first petitioner is seeking are captured at paragraph 148 all through to paragraph 148 of the submissions. This is appearing at page 61 of the submissions by the first petitioner.
Page?
Page 61. That is prayer number H. What are the appropriate reliefs? Starting from page, paragraph 148, running all the way to paragraph 152. And Your Honor, there has been various mentions of the issue of public participation. I want to address the prayer relief number 1, that is A, a declaration that the respondents have contravened the provisions of Article 10 and Article 118(1) of the Constitution by initiating a process leading to the removal of office by impeachment against the petitioner. My Lord, relevant to that particular prayer is the definition of what Parliament is at Article 93 of the Constitution. And this is what it says. There is established a Parliament of Kenya which shall consist of the National Assembly and the Senate. And very briefly, my Lord, we have been told there was some semblance of public participation conducted by the National Assembly. But on record, nothing has been demonstrated, or rather, the respondents, especially the Senate, has not given any indication that there was any semblance of public participation. The reason why I'm saying this is because Parliament is both the National Assembly and the Senate. Even if there was some public participation initiated by the National Assembly, there was none whatsoever that was initiated by the Senate. This is the reason why we are saying that there is violation of Article 118(1) of the Constitution, because the Constitution requires that Parliament shall conduct business in an open manner, and in its sitting and those of its committees shall be open to the public. It goes further to say that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So that then the question is, what happens when the Senate conducts its business without involving public participation, without invoking public participation? The answer can only be that there is a clear violation of Article 118(1) of the Constitution, and we pray that then the court finds that in favor of the petitioner. My lords and my lady, we have gone to pray for a declaration under B. I don't have to read the whole of it, but it has been explained by counsel that some of the charges that were confirmed against the first petitioner, there was multiplicity and duplicity of charges. That you have allegations and particulars being referred to in support of a given allegation. So that then what we pray under a declaration that we are seeking under B, motion lacks the particularization and specificity required by Article 145(1) of the Constitution. This is important because it was submitted by Senior Counsel Ongoya, and he explained in detail how the charges 3, 4, and 5, particulars that were relied upon were in particulars or the charges in A and B, charge 1 and B, so that there were no particulars in support of those other allegations. The next prayer that the petitioner is seeking is as regards the inconsistent and violation of the Constitution under B, a declaration that the resolution passed on the 8th of October 2024 by the National Assembly to impeach the petitioner pursuant to the provisions of Article 145 and 150, and the communication dated 8th October 2024 sent by the Clerk of the National Assembly to the Senate titled that are both founded on a process that is inconsistent and in violation of the Constitution of Kenya. The reason why this prayer is being sought, my lords and my lady, is for the reason that there were many inadequacies resulting to the impeachment process, both at the National Assembly and the Senate. So that the culmination of it is that the process was a sham, and whatever that resulted from that particular process cannot sustain the impeachment process. So that we pray that the court can grant prayer number C as sought in the amended petition. My Lord, we also sought a declaration that for the purpose of impeachment of the President or Deputy President of the Republic of Kenya, adequate public participation must be undertaken in all the 290 electoral constituencies in Kenya, the diaspora constituency, and the 1,450 electoral wards where the presidential election takes place. My lords, the background on this is that the election of the Deputy President and the President takes place at the polling station. Counsel who has submitted before me have explained to my lords that the initial notice that was given was that public participation was to be undertaken at the county level. Subsequent communication was that there will be public participation at the constituency level, without an indication as to where the venue and more details to allow members of the public to meaningfully participate in public participation so that they can give their views. So that without a clear communication that public participation was to take place in all the 290 electoral constituencies and the 1,450 electoral wards, then that process cannot be said to have met the constitutional threshold on meaningful public participation. It is for that reason then that, my lords, we pray that you can find in favor of the first petitioner the declaration that is seeking under D. The subsequent declaration is on the timeline that was given, a declaration that the 12-week period provided under standing order 64.2 and 64.6 of the standing orders of the National Assembly is grossly insufficient. My lords, I will not repeat that because Council Faith Waigua has elaborated on the inadequacies and the prayer to have the same declared unconstitutional. Subsequent to that, my lord, we have prayer number F. Most of those others I'll consolidate. A declaration that the proceeding before the whole House plenary of the Senate of Kenya under Article 145 of the Constitution of Kenya are not limited to time-bound 10 days. This is, my lord, what Ochiel Dudley explained, that the 10 days that the Senate imposed on itself was not, did not have any legal basis, so that it was not justifiable for the Senate to impose itself on a 10-day period to conclude the business in a very rushed manner. As it was indicated by the Speaker of the Senate, they wanted to do that with military precision so that they could attain a premeditated outcome in our submission. My lord, prayer number G is a declaration that the petitioner's right for fair administrative action under Article 47, a right to fair hearing under Article 50 of the Constitution were violated. My lord, it has been explained in detail how the first petitioner was denied a fair hearing, so that even at a point when he fell ill, it was communicated to the Senate, and Senior Counsel Paul Muite explained to the Senate the circumstances under which he was not able to proceed with the hearing before the Senate. The Senate proceeded, regardless of that particular communication, to proceed with the impeachment process. So that is a very clear indication that the process was not fair, and the rights of His Excellency Rigathi Gachagua under Article 50 were violated to the fullest. My lord, declaration number H that you're seeking is that the National Assembly and the Senate, in their evaluation of the impeachment proceeding before them, failed to properly assess each of the specified ground and determine if they collectively and individually constituted gross violation of the Constitution. My lord, it has been explained to you again that even where a provision of the law has been declared unconstitutional, the National Assembly and the Senate still proceeded to find and uphold those particular allegations. The alikees have been explained, and the court has been taken through the process leading to the invalidation and declaration of the unconstitutional provision under that particular act. But nevertheless, the National Assembly did not consider it necessary to find that some of those allegations were even illegal, were unfounded, and could not stand the test of law. Next to that is an order that this court quashes several documents and communication. I will not read each and every order, but we have sought orders of certiorari to remove and quash the communication of 8th of October 2024, 17th of October 2024, resolving to remove the office of, from office by impeachment His Excellency Rigathi Gachagua as the Deputy President of the Republic of Kenya. The reason for this, my lord, is, as explained before, that there were legal illegalities that were committed along the way, and these particular notices of 8th of October and 17th of October were the culmination of those particular illegal proceedings, so that the only justifiable cause that the court can give is to quash the notices of 8th of October and 17th of October 2024, respectively. Subsequent to that, there is also a request or a prayer that the notice by the Senate of 17th of October be quashed. This is the notice communicating the impeachment of His Excellency Rigathi Gachagua to the National Assembly. My lord, we have then all the other prayers that we have sought. And my lord, by the time someone is being elected to the office of the deputy president or any other office, the expectations that come with it. We have given an authority that this court can award damages where there are violations of the Constitution. This is the case of Imanyara versus Republic, where the court held that where there are violations of the Constitution, and this is at paragraph 151 of our submissions, my Lord, you'll have a chance to look at it. The case of Imanyara and two others versus the AG, 2016 Kenya law reports, that where the court said that award of damages for constitutional violation of an individual's right by state or government are reliefs under public law remedies within the discretion of the court. So that at paragraph O of our prayers, the first petitioner has come before you and is praying for general damages, punitive and aggravated damages. These are not far-fetched because the court has previously found that they are awardable by the court, because if we have demonstrated to the court that his rights were violated, then the court can award damages as prayed under paragraph 01 of our submissions. My Lord, we have also explained in detail that he was earning a salary that maybe I don't have to give a figure because there's a lot of calculations, mathematical calculations, but you will have a look at paragraph O, where we have listed the benefits that the deputy president was earning, what he was entitled to, and what his salary could have been if he worked for the 5 years that the Kenyan people had given him a mandate. So that we have therefore calculated those particular salary expectations and benefits that he was entitled to under the law. And we pray that the court can allow and award those particular prayers as sought. My Lord, the office of the Deputy President attracts some benefits, again, other than the salaries, which we have enumerated under paragraph P, because there are quite a number, including quite a number of issues, cleaners, gardeners, and all that. I believe that my lords will have a chance to look at those particular prayers and the allowances that he could have been entitled to could he have served his full 5-year term. We do have replay that the court will allow the prayers as sought, and I believe you'll have a chance to have a look at all of them in detail, one by one, in awarding and agreeing to allow the petition as prayed. I think, Mr. Mashari, you have a word to mention about it.
I just wanted to remind my colleague that he needed to emphasize that most fundamental matter called costs. We need costs on behalf of the Deputy President for all these bad things that have been done to him and to us. Thank you very much, my lords.
Well, that concludes.
Yes, Your Lordships and my lady, my name is George Sakimpa. We do appear together with Mr. Ogada for the 4th to 8th petitioners. Your Lordship, the petition that is before you is originally Kerugoya petition E015, and which has since been consolidated in these petitions. So, Your Lordship, I will only deal with 2 issues because I do not wish to regurgitate what my seniors have already said. So, Your Lordship, I will just handle 2 issues, the first one being on the element of public participation, and it is going to be in twofold. That is from at the impeachment level, and secondly, public participation in terms of the appointment of the Deputy President, Professor Kithure Kindiki. And the second issue, Your Lordship, is on the Senate and whether it was open for the Senate to apply the plenary route. So, Your Lordship, I will start with the first issue of public participation. Your Lordship, the principles of public participation have already been eloquently espoused here, especially the BAT Supreme Court case. So, Your Lordship, I will not delve into that. other than to add that there is an international association for public participation, which has since developed at least 7 core principles when it comes to public participation. Your Lordship, Kenya, under Article 2.5 of the Constitution, general principles of international law do form part of Kenyan law, and therefore we do rely on those provisions. And there are 7 principles, and basically they have been well captured in the Supreme Court case of BAT. So, Your Lordship, so I would not wish to mention the 7 of them, other than to be referring to them when it is necessary. So, Your Lordship, the most important element of this public participation is that it has to be qualitative and quantitative. So, Your Lordship, what I'm going to do in these short submissions is to go to the evidence and to actually demonstrate that the public participation exercise that was conducted on 4th and 5th of October 2024 were neither qualitative nor quantitative. So, Your Lordship, I will begin with the affidavit that was sworn by the 4th petitioner, that is Honorable David Munyi Madenge, where, Your Lordship, in that affidavit, he says that he had no opportunity at all to participate in terms of echoing the views. And what was the reason for his inability to air his views? Your Lordship, the reason is that when he went to the designated center, Your Lordship, that center was closed. First of all, Your Lordship, the center was not open. It was closed, and there are evidentiary documents that were attached to his affidavit to confirm that that venue was closed. And that is what he has deponed in his affidavit, to the effect that he did not participate at all, because all the residents of Kirinyaga in that instance who went to that particular station did not participate. They dispersed without having given their views in terms of the impeachment of the second deputy president. So, Your Lordship, the next issue is on the issue of the notice. Your Lordship, from the notice, especially the extension notice of public participation, that notice was pursuant to the orders that were issued by Honorable Justice Richard Mwongo in a petition that was earlier filed, and where the judge said that the modalities that were put by the National Assembly were not sufficient, and therefore ordered for a second phase of public participation. So, Your Lordship, what the National Assembly did, instead of going back and preparing for a proper public participation as was ordered by the judge, they simply extended the public participation. Your Lordship, from the annexure that we filed, that is DMM1, Your Lordship, the notice is actually dated the same day when the extension was actually supposed to happen. So, from the daily newspapers that were filed, Your Lordship, it was on the very same day, that is on 5th of October 2024, telling the public that we have extended the public participation. So, Your Lordship, that notice was not enough, and even from the affidavits that was sworn by the 5th, 6th, 7th, and 8th, realized that the extension was given after, in fact, on the next day. So, in short, Your Lordship, because I don't want to repeat what my colleagues have already said, it is our humble submission that this court return a finding that indeed the notice was not sufficient for a meaningful and qualitative public participation. So, Your Lordship, on the other issue of quantitative aspect, my learned senior, Mr. Tom Masharia, had given a percentage in terms of the qualitative aspect, that out of 50 million Kenyans, only 200,000 gave their views in respect to the impeachment of the second deputy president. So, Your Lordship, that translates to 0.04%. And that is what basically said it's still 0%. So, Your Lordship, it was not quantitative and it was not qualitative. And Your Lordship, I only want to mainly emphasize on the decision that we filed, Law Society of Kenya versus National Assembly, 2025, where of course the court, in agreeing with the BAT case, the court said that public participation must be real. It is not a cosmetic or a public relations act. It is not a mere formality to be undertaken as a matter of course just to fulfill a constitutional requirement. There is need for both quantitative and qualitative components in public participation. So, Your Lordship, I have already submitted that it was neither qualitative nor quantitative. So, Your Lordship, I want to go now to the next issue in terms of the public participation in respect to the appointment of Professor Kithure Kindiki as the Deputy President. So, Your Lordship, and I'll be referring to the memorandum that was signed by the President. And your
She is kind of a big deal. And no, it's not about her big office. Thanks to her big connection that keeps her big business always on. You too can be a big deal when you keep your business always on. Enjoy monthly payments, zero interruptions, predictable billing, and best-in-class coverage without daily recharges. Stay on always with Airtel Business Postpaid. Call 125 or email business.support@ug.airtel.com to sign up. Airtel, regulated by the Ghana Communications Commission.
Constitution, a vacancy has arisen in the office of the Deputy President. So, Your Lordship, in relation to that, our submission is that this nomination of Professor Kindiki was subject to the Public Appointments Parliamentary Approval Act, that is Cap 7F of the laws of Kenya. And Your Lordship, in respect to this particular act that I'm referring, the Presidential Memorandum of Nomination is substantially in compliance with the provision of this act, except on the element of public participation. That is where the National Assembly drew the line, that the memorandum of did comply substantially with the act, but they chose not to undertake public participation. And I will start with the objective of this act. So, and the act says it is an act of parliament to provide for procedures for parliamentary approval of constitutional and statutory appointments and for connected purposes. So, Your Lordship, from the memorandum by the President of nomination, it is clear that this is a constitutional appointment because he actually says that pursuant to the provisions of Article 150, a vacancy has arisen in the office of the Deputy President. So, in essence, Your Lordship and my lady, this is a constitutional vacancy and a constitutional appointment that was subject to the provisions of the Public Appointments Parliamentary Approval Act. And Section 3 of that Act says that the exercise of powers of appointment. So an appointment under this Constitution, that is Section 3, an appointment under this Constitution or any other law for which approval of Parliament is required shall not be made unless the appointment is approved or deemed to have been approved by Parliament in accordance with this Act. So, Your Lordship, it is clear that the appointing authority in this case was the President. So after appointing Professor Kithure Kindiki as a nominee for the position of the Deputy President, it was subject to the application of this Act. And as I said, Your Lordship, the memo complied completely in all aspects with this Act, save for public participation. So, and Section 5 also provided for notification of nomination. And it says that an appointing authority shall, upon nominating a person for appointment to which this Act applies, shall notify the relevant House of Parliament. So it is through this Presidential Memorandum of Nomination that Parliament was notified of this appointment of Professor Kindiki. And it further says that a notification of appointment shall be accompanied by information concerning the nominee having regard to the issues mentioned under Section 7. So, Your Lordship, I am sure that you will have an opportunity when you retire to examine this presidential memorandum. And in fact, it does highlight that the President says that for reasons whereof I have enclosed the following documents, and which Senior Counsel Paul Mwite said that it was done in an ungodly speed. So, Your Lordship, I want to reiterate that the essence of this act was provided by Parliament so that it provides safeguards, especially on the issue of public participation, where the citizens will be given an opportunity for them to give views on the new nominee. And that is the procedure even in terms of the appointment of cabinet secretaries and all the appointments that are made under the Constitution. And Section 6, which is the most important part, it says that the committee, Section 6(4), approval hearing. So the committee shall notify the public of the time and place for holding an approval hearing at least 7 days prior to the hearing. So, Your Lordship, 7 days prior to the date of the hearing. Your Lordship, of course, from what we've heard is that the impeachment was done on the 17th of October, and on the next day, that is when the President forwarded this memorandum of appointment. So, Your Lordship, from that moment, the law requires that before the approval was done, the public had to have been given a notice of at least 7 days. So, Your Lordship, and the President further says, in forwarding this nomination, that, and he quotes Article 149 of the Constitution, which says that within 14 days after a vacancy in the office of the President arises. So, Your Lordship, within 14 days, of course, this was done within a few hours. It was, the impeachment was done at night, and in the morning, the President did this act. So the President shall nominate a person to fill the vacancy, and the National Assembly shall vote on the nomination within 60 days after receiving it. So, Your Lordship, under Article 149, the Constitution gave 60 days for Parliament to consider the appointment of the new nominee. And the reasoning, Your Lordship, is there are these documentations that have been given by the President forwarding the nominee. Parliament was under an obligation to consider those documents within a period of 60 days. Your Lordship, by midday on 18th of October, Parliament had already voted on the issue of appointment of Professor Kindiki in complete disregard of Section 6(4) that required the public was to be given at least 7 days so that they can give their issues in terms of the suitability of the Deputy President nominee. Your Lordship, but obviously that was not done. And Your Lordship, I'll also now refer to the response that the National Assembly, in their submissions, they have filed, or rather they have given a ridiculous response to these submissions that we made. And under paragraph 361 of their submissions, they say that, in fact, this was a sui generis, procedure, to the effect that it was not an approval, but a vote by the National Assembly. Your Lordship, assuming even we take the argument that they say that in fact it was a vote and not an approval hearing, Your Lordship, then the provisions of Article 118 of the Constitution will then apply, because they will still need to conduct public participation as required under Article 118. And Article 118 provides that public access and participation. So it says that Parliament shall facilitate public participation and involvement in the legislative and other business of Parliament and its committees. So, Your Lordship, even if they escape the provisions of Section 6(4) of this act, of the Public Appointments Parliamentary Approval Act, then they cannot circumvent the provisions of Article 118.
When you gotta go, go for Neptune, the softer two-ply tissue paper, available in plain white and colored.
Court said that the purpose of permitting public participation in the law-making process is to afford the public an opportunity to influence the decision of the lawmakers. So, Your Lordship, assuming that we were to take the proposal that they said that this was a vote that ought to have been taken by the National Assembly, then under Article 118, they must have sought public participation before they made the vote to approve the Deputy President nominee. And Your Lordship, they further give a fallacious explanation and say that actually it is equal to the election of the Speaker and Deputy Speaker and members of the regional parliament, that is IALA. So, Your Lordship, that is not true. In this case, this nominee is directly appointed by the President, and there is a memorandum of presidential appointment. In the case of a Speaker and members of the East African Legislative Assembly, they are directly elected by Parliament, or rather in whichever house that is applicable. So there is no nomination that happens by any authority in terms of before the Speaker is elected. They are directly elected by the members of Parliament. So, Your Lordship, the last issue that I'm going to discuss as I conclude is on the issue of whether the Senate violated Article 145 in terms of taking the plenary route. Your Lordship, our submission is that it was not open in law for the Senate to take the approach of the plenary. And my learned senior Ochiel Dudley had already discussed Article 145.3. So, Your Lordship, I will not belabor on that point, other than to submit that under that provision, that is Article 145.3, where it says that the Speaker of the Senate shall convene a meeting of the Senate to hear the charges against the President, and the Senate by resolution may appoint a special committee comprising 11 of its members to investigate the matter. So, Your Lordship, even if we were to apply all the statutory, or rather all the interpretations, rules of interpretations of the Constitution, all of them will point to the position that the appropriate route was the special committee. And Your Lordship, there is, the first rule is the literal, of course, interpretation of this provision. It is clear that from the reading of that provision, there is nowhere in which the framers of the Constitution provided that a plenary session can be held to investigate into the conduct of the Deputy President. And in fact, Your Lordship, from Article 145, it is clear that the Constitution was very clear in terms of the impeachment of the President, because it does apply to the President, and of the Deputy President. It went further to actually provide what needs to happen. And it is a constitutional buffer that was put there to ensure that whoever is undergoing the process of impeachment will get the benefit of the law. And I will shortly be reading the provisions of Article 27 of the Constitution, where it actually provides for equal benefit of the law. And maybe I can just quickly, as I finalize, read section 27(1), which provides that every person is equal before the law and has the benefit and has the right to equal protection and equal benefit of the law. So, Your Lordship, under Article 27, there is a benefit that has been, under Article 145.3, there is a benefit that has been put there by the Constitution, and which the second Deputy President was entitled to benefit from this provision of the Constitution in terms of having a special committee to investigate into the allegations that were leveled against him. So, Your Lordship, and if we look at actually that provision again, if we were to take the position that actually a plenary is also a route that is provided here, it will actually amount to a discriminatory act in the following sense, my Lord and my Lady, that it means that the Senate will be deciding. There is no criteria as to when the special committee will be applied by the Senate and when a plenary will be applied by the Senate. And Your Lordship, what that means is that it will depend on whether the Senate actually, you are in good books either with the Senate or whoever who is in charge of those impeachment. Because there is no procedure that actually provides that under these circumstances, a special committee must be undertaken, and under these special circumstances, then the plenary can be undertaken. It is left to the Senate to determine at whichever time they are going to use whichever mode. And Your Lordship, that has been demonstrated even in the impeachment of governors, where you find that some governors are subjected to the plenary, others are subjected to the special committee without any justification why this was used over that. And therefore, the purposive interpretation and holistic interpretation of this article will yield a conclusion that at all times when it comes to the impeachment of the president or the deputy president, a special committee must be constituted by the Senate for purposes of hearing, investigating, first of all, whether the charges have been substantiated before a recommendation is made to the Senate. And finally, the other rule that I want to rely on is on the Latin maxim that expressio unis est exclusio alteras. So, Your Lordship, that provision basically means that what has been expressly provided under the Constitution, any other thing is excluded. Your Lordship, the framers of the Constitution, if they wanted to have both modes available, then, Your Lordship, there was nothing difficult in them saying that either they investigate by the committee or by plenary. They expressly excluded the provision of a plenary, because what the Constitution wanted is a process where the president or the deputy president is given an opportunity to, first of all, for the Senate to first of all investigate by the committee, and finally that the matter be deliberated in the Senate. So, Your Lordship, in light of those brief submissions, we do pray that this Honorable Court finds that the impeachment of the second Deputy President was unconstitutional, invalid, and null and void. Those are my humble submissions.
Can you in just 1 second tell me the remedies we're seeking in this petition?
Yes, Your Lordship. In our petition, we have several prayers that we've sought, and the first prayer is a declaration that the appointment of Professor Kithure Kindiki as the Deputy President of the Republic of Kenya was invalid, null and void for the reasons that we've given in terms of there was no public participation. Your Lordship, another prayer that we did. Another prayer that we sought for a declaration that the public participation that was conducted by the National Assembly on 4th October and 5th of October was not proper, effective, and meaningful within the provisions of Article 10 and 118 of the Constitution. And finally, that the impeachment process of the first interested party, being the second Deputy President, was invalid, null and void. Those are the submissions. And Your Lordship, of course, cost of this petition.
Thank you very much.
And we do support the position that was taken by the first petitioner. Most obliged, my Lord.
Thank you.
Jiro Kimotho Makazi from Tess Kimotho and Company Advocates Kerugoya. I'm for the second petitioner. So my petition is the one dated Okay, thank you. It's the one dated 25th September 2024. And in that petition, we are seeking several orders. And in those orders that we are seeking, one, we are seeking that the then Honorable RIGATHI GACHAGUA, there be a declaration that the constitutional rights of the applicant, who is the petitioner, provided for under Article 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. And that the first respondent, who by then was the current Deputy President, be ordered to issue an apology to the NIS members and staff due to the utterances and speech made on the 26th June 2024. Cost of the petition and any other relief the court may deem fit. Of course, we wish to say that our petition has not been opposed by anybody. Let me finish. And we rely, of course, on the facts in support of the petition and our supporting affidavit as it is. We also wish to say that the reason why we had done an application to stop the impeachment proceedings is because...
My Lord, I don't like doing this. But clearly, Ms. Kimotho's petition is overtaken by events. The petition sought an apology by the second Deputy President to the NIS. That did not happen. The impeachment occurred. A vote was taken on that question, and it is the subject of the first petition argued by Senior Counsel Paul Mwite. So Ms. Kimotho should sit down. Thank you.
No. We are opposed to that because that's not true. The apology we were seeking is an apology from the Deputy President, whether he's sitting or not sitting. So we are very much in place. And again, we also wish to as I proceed before I was interrupted by my senior, I wish to say that we are also in support of, we are against the process of impeachment. And we are going to say why, if I'm allowed to say. The reason why we are in support of, why we are against, the impeachment process is that the grounds that we relied on in our petition are the same grounds that were being litigated by the Senate. The judge, when we went to, our petition was first, E013. When we went to the High Court at Kerugoya, we raised these issues. The Senate had not yet started the process, the impeachment process. And so we felt that if we were hard fast, then this whole issue would have taken a different turn. Because once a case is pending in court, once the issues that are being raised are the same issues being raised in the Senate, then we ought to have been hard fast. And that's what we have been raising from the application that we did, and even in this situation when we are arguing our petition. We again say that if you look at the entire process, any person who goes to court must be heard. That's an Article 50, fair hearing. Then if the same issues that are being raised here are raised there, then of course there's an issue. It shows the senator, because we served the Senate, and the Speaker clearly acknowledged that there's a petition going on in Kerugoya, but they ignored. This can only show their minds. They had made up their minds. And that's why now we are in support of the petitioners against the entire impeachment process. And this point is very, very important. Again, if you look at when we were consolidated, there came the issues again that are being raised here. Public participation, which on our part, we are supporting. We are saying the public participation that was done was not done well. His Excellency Rigathi Gachagua, His Excellency the President of Kenya, William Ruto, are people who are voted by Kenyans as a duo, not individually. So now when His Excellency, one duo, one person, one part of that duo is subjected to impeachment without the same process that was used to bring them to power, then that issue violates the Constitution. And why are we saying this? If you look at how they were elected, polling stations were everywhere. Each constituency, each polling stations in the wards, people were allowed to vote. So now when it comes to public participation, in where now we want to remove one duo, why are Kenyans not being told, come, let's get your views on the removal of one duo that we elected? How can we be told we don't have a right to be here right now? We do have a right, because if Kenyans did not participate equally as they did participate during the elections campaigns, then the process, any public participation that is said was done here was a sham. The second issue, why we are in support of these petitioners. Again, you can see how, and these allegations that are in public domain. In fact, in our petition, we are accusing the Attorney General of these issues. Everybody kept on saying the MPs were given 500,000. The senators were given 1 million. These are allegations in the public domain. Can we say this process was fair when people out there are claiming there is bribery? We have seen several talk shows, people continuing saying these issues.
The orange car breathes and zooms on its way. A spinning spiral sun starts the happy day. Cheering trees wave and the fish jump high. The winking sun glows in the sky.
What happens? The Senate does not care. They give a few hours, a few days, and then say, we will proceed, whether he appears before us or not. We go back to Article 50, fair hearing. Fair hearing means, however that person is, he must be allowed to give us his side of story. Kenyans were waiting. Kenyans were watching the TV. They wanted to hear His Excellency Rigathi Gachagua tell us, we voted for him. We want to know what happened. What happened, yet we voted a duo. So this chance we were not given. What we saw was in Senate, people come in and the lawyers speak and other allegations, paperwork. So the Kenyans would have expected to hear his side of story. So in that, we say he was not given a fair hearing, and therefore that impeachment process was not conducted the correct way. I think my points, those are my few points. They are very fiery, so I don't want to keep.
Of course they are.
Yeah, I don't want to spoil anything. That's all for me.
Thank you. Yeah, they are fiery. Thank you very much.
Okay.
Yes, thank you.
My lords, your leadership, the court will recollect that when we last appeared before this noble court on the 24th of February 2025, I stated to this honorable court on record, on behalf of His Excellency RIGATHI GACHAGUA, that he was abandoning his prayer for reinstatement as Deputy President of the Republic of Kenya. To that end, His Excellency RIGATHI GACHAGUA amended and served his re-amended petition dated 13th of August 2025, in which further re-amended petition, he abandoned the prayer for reinstatement. I wish again, my lords, your leadership, to reiterate that position on record. My lords, the prayers of the first petitioner are set out in prayers A to R in the said further amended petition, which, as I have said, is dated 13th of August 2025. The core of those prayers can be summarized as follows. One, the question, if this court agrees with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration he would have otherwise earned, plus, of course, all the benefits as per the law, plus damages. Finally, for the period of 2.5 years that His Excellency RIGATHI GACHAGUA served as the second Deputy President of the Republic of Kenya, it is our submission that Article 151 of the Constitution is fully applicable, and I invite your Lordship and your leadership to have a look at that Article 151 when you retire. Briefly, my Lord, impeachment cannot and could not have been retrospective. That is the submission. My lords, your leadership, the petitioner, first petitioner, relies on the following documents. One, his further amended petition dated 13th of August 2025, the verifying affidavit thereto, and the annexures, which are in 9 volumes, dated 18th of October 2020, of authorities and case digest, dated 7th of October. And number 3, the first petitioner's written 7th October 2025, which submissions are the ones we are highlighting today before this noble court. My Lords, paragraph 1 to 19 my colleague is drawing my attention that we also relying on the first petitioner's rejoinder to submissions, which you are served rather late in the day, but the rejoinder is dated 27th of April 2026. Thank you. My Lords, Your Ladyship, paragraph 1 to 19 of our written submissions sets out the critical background and gives context to the impeachment and the submissions we have made with regard to that impeachment. And I politely invite this honorable court, when it retires, to read this background in full. But permit me to briefly draw the court's attention to only 3 matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. And I would draw this honorable court's attention to paragraph 5, which you will find at page 7.
Your uncle wants you to get a loan. He says you should buy a Beamer to stop embarrassing him in front of his friends with your malnourished car. That you should buy one of those expensive shirts they call Versace, so that people stop spreading rumors that his family has no style. That you need an iPhone because he's tired of biting his tongue whenever he tries to pronounce that funny thing you're holding. Good thing you've got ABSA. Our loans are not designed for others to change what they say about you. They are designed to support your growth. Visit absa.co.ug for personal loans that help where it matters. ABSA, your story matters.
The exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the allegation made by the National Assembly. And our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was saying. But that was never done. In Nairobi, for example, in the county of Nairobi, the National Assembly public participation for the county of Nairobi, capital city. The public participation at the Bomas of Kenya was presided over by select ODM members of parliament from Nairobi County, who repeatedly asserted that the event was for invited guests only. Lord, it is our submission that that is a mockery of effective public participation under the Constitution. And you'll find what I'm saying in the exhibit, my Lord, in exhibit marked RG 5 in volume 6, page 757, to 758. And also exhibit marked RG7 in volume 6, page 764 to 765. My Lord, the second issue I would like to highlight is the rush from the word go, that the entire process was conducted by the National Assembly through to the Senate, breakneck speed, lightning speed. And the question that arises is why this speed? And our submission is that the only inference that can be drawn, and we drew, and we invite this report to draw, is that there was a predetermined result that the National Assembly and the Senate were rushing to achieve. Technical perception that they were doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 8, 9, and 10, and 11, and they appear from page 8 of our written submission. Paragraph 8, the Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8th October 2024, which then passed a resolution that the plenary would hear and consider. And I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person to be impeached is to get any fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law, that the rules of natural justice and on a correct interpretation of the relevant provisions of the Constitution, the standing order, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee to fully present his evidence, be represented, and be heard. And the 10 days that later the Senate imposed itself on refer to the committee of the Senate, not to the plenary. Lord, paragraph 9, hearing before the Senate commenced as scheduled on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was fully discredited in cross-examination, and this Honorable Court will be taken through all that. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the Deputy President 2 hours to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Yet, the person that was being impeached was the Deputy President of the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the National Assembly, despite on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated, he fell ill and was rushed to hospital for urgent medical attention. Rejecting the request for adjournment, the Senate voted to impeach.
We are in the business of action, of taking the hard path, of untethered ambition and restless innovation, of leveraging strong connections and accelerating growth, harnessing local opportunities on a global scale, nurturing masters of the art and empowering their craft. We are in the business of never slowing down. Because when you serve a 40 million strong nation with unmatched regional economic potential, the endless pursuit of greatness becomes your business. Hugamara Group, making greatness every day.
For both the National Assembly and the Senate to address their minds to the threshold that the Constitution lays down for impeachment of a person elected into office by a plurality of votes. And here, my Lord, permit me to draw the court's attention to the fundamental distinction between presidential systems of government and parliamentary systems of government. In a parliamentary system of government, members of parliament are entitled and have the right to kick the prime minister out of office simply by passing a no confidence resolution. No one can question the members of parliament why they had lost confidence in the prime minister. There are many examples of parliamentary system. England is a parliamentary system. India is a parliamentary system. And in fact, although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. So that distinction is important. The people of Kenya decided in August 2010 that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution that members of the National Assembly can vote and christen their resolution that there are breaches of the Constitution, and you'll be addressing this fully, when in truth what they were doing was simply to say we have the numbers, passing a vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, if you look at paragraph 1 of our written submission, this is important. an impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being impeached. One of last resort. Let me pause here to emphasize, in the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported to the National Integration Commission. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted? That was not respecting the important dictate in presidential system that impeachment is the last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, through a plurality of their votes, who elect both the president and the deputy president. The remedy should be limited to only the gravest political wrong. This is because the person to be removed from office came to that office through a popular mandate. The will of the people should therefore not be overturned on flimsy grounds. In other words, what I am highlighting here is what the court says in the song called Moving Gideon Kyoko, and another was of Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must therefore be shown that the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president. It is incumbent upon the High Court, and this is important, it is incumbent upon the High Court to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is, my Lord, as I say, the first time that the first petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or the written law that the Constitution prescribes. Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. Lord, if you go to page 11 of our written submissions, you will...
You're sinking. You feel the pressure, the unknown. It's closing in. You try to stay strong, but the worries of the future feel like they're pulling you under. Life seems chaotic and out of control. In the storms of life, where do you turn? In times of uncertainty, there is one that will carry you through. He is an anchor of hope and peace. That anchor is Jesus, God's Son, who died on the cross for you. He took our burdens upon himself, then rose from the dead to offer eternal life to anyone who asks forgiveness and trusts in him. When things feel unstable, you don't have to drift through the unknown alone. Let Jesus be the anchor that holds you steady. Click to connect with an online volunteer to learn more about starting a relationship with Jesus.
Different dimensions to each of the issues that will be addressed by different countries. Now, the issues I want to address in those issues listed in paragraph 17 are one, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one is C, whether the Senate, misled by its interpretation of Article 145, rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy President was denied a fair hearing. And a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2010 Constitution. And the third one is whether the overnight clearances for the replacement Deputy President evidenced a predetermined process compounded by the violations, whether that was unconstitutional. My Lords, Your Leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly simply did not meet the constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, which is the motion. My Lord, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove gross violation must be proved before the relevant constitutional order. My Lord, Your Leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing the Wambora case. It is a high standard in presidential systems. Not each, and you'll find that in the Wambora case, our Bundle of Authorities, paragraph 45, pages 45 to 46. Not each violation of the Constitution amounts to gross violation. No, the drafters of the Constitution could have said violation of the Constitution or other reasons. They didn't. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wabora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged against the governor, in this case deputy governor, may I say, not just the deputy governor, the law that this court will be laid down or reiterated will apply to the impeachment of the president himself. It's very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law. The charges framed against the governor or deputy president of the country and the particulars thereof must disclose a gross violation of the Constitution or any other written law. D, the charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, and wholly unfounded. Besides, the National Assembly erred in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017, 6090, nullified Section 132 of the Penal Code. The court nullified Section 132 of the Penal Code. 5 years before the Deputy President's election to office, ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warranting his removal from office by impeaching the Deputy President on the basis of a section that had been nullified by this court. What he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty. For among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Ladyship, the Senate voted on that impeachment charge on the basis of a repealed section. And you find that in Exhibit RG3, Volume 6, pages 745 to 747. And my Lord, although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in Ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing a public security. And my Lord, what offense was the National Assembly stating here? What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239, and in fact the NIS Act, that the NIS, under the Constitution, 239, sub-article 5, is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is 206 of the laws of Kenya. You will find in Part 3, Civilian Authorities, the heading, Effective Surveillance Authority. They then say that the Cabinet Secretary will be the civilian authority oversight. The Cabinet Secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that would take up these issues. But criticism, despite the freedom of thought and expression in our Constitution, the first petitioner was still convicted for criticizing the NIS director. So, my Lord, Your Ladyship, what you are submitting here is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, Ground 5 accused the Deputy President of grossly violating Article 3(1) and 148(5)(d) of the Constitution and of failing to uphold his oath of office and allegiance. There were no details provided. Instead, Ground 5 simply referenced ground 1, 2, 3, and 4. This unfair and confusing charge was such that even though the Senate cleared the Deputy President of ground 2 and 3, it still voted to impeach him based on ground 5. There was no attempt to explain, even vaguely, how the Deputy President had violated his oath of office. Ground 6 equally alleged that there were serious reasons to believe that Rigathi Gachagua had committed crimes under Section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why wasn't he taken first to the National Cohesion for prosecution before invoking the last resort remedy of impeachment? Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent, irrefutable, factual, and legal response to each of the 11 grounds cited in the impeachment motion. Lord, you see that in Exhibit RG2, Volume 2, pages 211 to 240. For instance, concerning the claim in ground 8 that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering, the Deputy President explained that no valuation had been done, so where the National Assembly, Honorable Wengi Mutuse, got 5.2 billion is anybody's guess. If you want to charge somebody, you present evidence that this is the value of this property. Further, from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother, the late Honorable James Derito Gachagua. May his soul rest in eternal peace. To 214. Lords, although the mover of the motion listed that the 2 companies associating them with the petitioner, first petitioner, alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety, and you find that in RG2, Volume 2, pages 214 to 218. The Speaker of the National Assembly, again, a good professional colleague who I respect, did not direct the members to the threshold test, the appropriate standard. Hence, the resolution was passed in proceedings conducted as a vote of no confidence rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you'll find that as message of the Senate, number 025 of 2024, approval of special motion, RG3, volume 6, 745 to 745. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds that, one, the impeachment motion was replete with the general unsupported allegations, hearsay, and outright lies, and lacked particularization and specificity required by Article 145(1) of the Constitution of Kenya and Standing Order 64(1)A of the Standing Orders of the National Assembly. 2, members of Parliament debated and voted on the motions on grounds other than those set out in the motion. The impeachment was converted into a vicarious assault on family rather than investigation of constitutional violations by a public servant. Members of Parliament, let me skip that and go to the next one. The entire impeachment process was designed to avoid and be ring-fenced from scrutiny and accountability, pushed through with uncharacteristic speed with the intention of ramming the process through before it could be audited for constitutional compliance. The National Assembly prosecuted proceedings on the basis that the petitioner offended the president rather than the Constitution. What the 2010 Constitution provides is violation of the Constitution. In other words, the president must take time and choose his deputy. My Lord, I don't need to take time to go through what the country was put through between His Excellency Daniel Toroitich Arap Moi and his Vice President George Saitoti dangling the Vice Presidency, requiring the President to choose his or her deputy before the election so that the people could themselves vote is a very important aspect.
Forged from the love of liberty in the fires of hope and prayer, with boundless faith in our destiny, we solemnly declare, side by side we stand, islands of the blue Caribbean Sea, this our native land. We pledge our lives to thee. Hear every creed and equal place, and may God bless our nation. Here every creed and race find an equal place, and may God bless our nation.
Heavenly Father, we come before you at the start of this new day, giving thanks for life, for health, and the opportunity to serve through this station. We ask for your divine presence to guide us in all we do. Bless this broadcast, that it may be a source of inspiration, joy, and unity to all who tune in. Whether near or far, may our words uplift, our music heal, and our message bring light to those who need it most. We pray for our listeners, wherever they may be. Grant them strength for the day ahead, peace in their hearts, and success in all they put their hands to. Cover those traveling with your protection and those at home with your comfort and provision. Lord, may everything we do bring honor to you and be a blessing to others. Guide our steps, bless our efforts, and let this station be a vessel of positivity and hope. In your name we pray. Amen.
Your voice, your soundtrack, your station. New Era TT Radio. Net Radio.
It's about that time again. We're gonna have a lot of fun tonight. H2O flow style, baby. I feel so good. This song is about fun. This song is